when attached to a firearm, does not convert that weapon to be fired from the shoulder.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
Firing rapidly, almost at the same rate as a machine gun, and that's why these will be banned starting tonight.
I view this ATF's recent pistol brace rule as a direct assault on veterans.
Now, there has been several injunctions already issued by multiple courts.
ATF derives its rulemaking authority in this matter from primarily the National Firearms Act.
The ATF has decided to take a chance and appeal 2 pistol brace cases to the 15th Circuit Court of Appeals. One of these cases is an appeal of the recent nationwide pistol brace order. U.S. pistol brace rule likely illegal. A federal appeals court found that a law in the U.S. that restricts possession of arm modifications, known as pistol braces, is likely illegal. This decision was a triumph for an arm rights group that had challenged the rule. The United States Bureau of Alcohol, Tobacco, Firearms and Explosives, the ATF, ultimately decided to implement the regulation in January without providing the general public with a significant opportunity to comment on it, according to a panel of the 5th United States Circuit Court of Appeals, which is situated in New Orleans. The panel came to the conclusion that this rendered it invalid in accordance with the Federal Administrative Procedure Act. Instead of immediately blocking the rule's enforcement, the court decided to refer the matter back to the United States District Judge Reed O'Connor in Fort Worth, Texas. It will be up to O'Connor to decide whether or not to issue an order that will prevent enforcement while the lawsuit is being heard, and if she does, she will have to determine whether or not the order will apply to the entire country or merely to the plaintiffs in the case. Several federal judges have already granted preliminary orders that prevent the rule from being enforced. The rule was created by the administration of President Joe Biden and has been challenged by lawsuits filed by groups that advocate for the freedom to bear arms. But the orders are only applicable to individuals who are members of the groups, and only within the jurisdictions of those judges. The complaint was filed by the Firearms Policy Coalition, which is an organization. One of the attorneys representing the group, Cody Wisniewski, referred to the decision as a huge win for peaceable arm owners across the nation. Both the ATF and the Department of Justice of the United States declined to comment. Pistol braces were initially introduced to the market in 2012 as a means of securing a firearm to the shooter's forearm, so adding stability to the firearm and making it more accessible to individuals with disabilities.
I want to get a better sense of where the ATF's pistol brace rule derived from.
This ruling has effectively, and for now at least, killed ATF's pistol brace.
When attached to a firearm, does not convert that weapon to be fired from the shoulder.
Firing rapidly, almost at the same rate as a machine gun, and that's why these will be banned starting tonight.
However, a number of users discovered that the bracing could also be positioned against the shoulder, similar to how the stock of a rifle is positioned. The contested regulation classifies some firearms that are fitted with pistol braces as short-barrel rifles. This classification is based on a number of considerations, including the size and weight of the firearms, as well as the marketing materials provided by the makers. Due to the fact that they have the potential to be more lethal than handarms, short-barrel rifles are subject to special registration, lengthier waiting periods for purchase, and higher taxes. Special registration is also required. In a letter that was published, Judge Jerry Smith of the Fifth Circuit stated that the final rule that the ATF had issued was very different from the proposed rule that it had presented for public comment in 2021. According to the judge, this constituted a rug pull on the public. In a concurring opinion, Circuit Judge Don Willett stated that the regulation most certainly violated not just the Administrative Procedure Act, but also the freedom to bear arms, as outlined in the Second Amendment of the Constitution. This was an issue that the majority of the judges did not consider. In his dissenting opinion, Circuit Judge Stephen Higginson stated that the final rule did not necessitate submissions from the general public because it merely interpreted a law that had been established by Congress. With regard to Higginson, He was appointed by former Democratic President Barack Obama, while Smith and Willett were appointed by previous Republican presidents Ronald Reagan and Donald Trump, respectively. Preliminary injunction granted. A collective headache is being experienced all around the country as a result of the legal haze that surrounds the final rule on stabilizing the arm bracing that was issued by the ATF. Everything began on December 18, 2020, when the ATF published an official notice exercising its rulemaking authority. This was the beginning of everything. A notification was issued by the ATF requesting that firearms of the AR style that were fitted with stabilizing bracing be reclassified as non-firearms goods. In spite of the fact that this action was foreseeable, the ATF was unable to come to a conclusion and ultimately decided to withdraw the regulation. On the other hand, just when the ATF was about to change its mind, it occurred once more. ATF proposed Rule 2021R-08, factoring criteria for firearms with attached stabilizing braces, was signed by the Attorney General on June 7, 2021.
And would not alter the classification of a pistol or other firearm.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
While a firearm so equipped would still be regulated by the Gun Control Act,
turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
such a firearm would not be subject to the NFA controls.
This rule amends the regulations of the ATF to specify the circumstances under which a rifle is intended to be fired from the shoulder. In reaction to the most recent rule that was proposed, arm owners made their voices heard during the period of time that was designated for notice and comment. In spite of the fact that there has been a significant amount of opposition, it appears that we are on the verge of a significant change in the way that arm-stabilizing arm braces are handled. The factoring criteria for firearms with attached stabilizing braces was adopted as 2021R-08F, which is unfortunate for those who possess firearms. In this video, we will talk about the final rule on pistol braces, when the rule will go into effect, amnesty, which has now been passed, injections, and what we know so far about these topics. The pistol brace, a summary of its description. Initially, the arm brace was designed to look like a shoulder stock. This was just the beginning of its development. When a shoulder stock is attached to an AR-style pistol that has a barrel length of less than 16 inches, the firearm is transformed into a non-handgun weapon, more particularly a short-barreled rifle, also known as an SBR. This is a crucial point to realize. On the other hand, producers of firearms and accessories requested pre-approval from the ATF to guarantee that these braces would not transform AR pistols into sidearm rifles. The ATF first came to the conclusion that braces did not transform a handgun into a self-defense rifle, despite the fact that they have taken a variety of positions on these things throughout the years, some of which were inconsistent. Then what has changed? Over the course of time, the ATF took the opposite position, which was that certain design aspects of the stabilizing braces would transform an AR-style pistol into an SBR.
Is the goal of the ATF to go after and criminalize law-abiding Americans?
That's not for us to regulate. If somebody we wrote the rule to make it easy to comply with.
I view this ATF's recent pistol brace rule as a direct assault on veterans.
This rule redefined firearms with stabilizing braces as short-barreled rifles.
This was communicated to industry producers of firearms and accessories through private letters. A decision was made by the ATF to exercise its regulatory authority through the use of targeted, private, and informal decision letters, rather than through the use of conventional rule-making procedures. Because of these letters, the people who own firearms in this country are now faced with a regulatory system that is unclear, and they have no idea how to traverse it. It is also unclear what the current position of the ATF is. It appears to take the following position. Numerous stabilizing braces allow the user to shoulder a pistol on purpose, rather than being utilized for the purpose for which they were designed. In point of fact, some of these braces are being sold as being of this type. although this marketing strategy is in direct opposition to the purpose for which the stabilizing braces were designed. The ATF is of the opinion that an AR pistol that is equipped with a stabilizing brace may now be regulated as a submash gun. Comment process and notice of changes. Why should we wait to issue a concrete rule before soliciting feedback from the general public? To put it succinctly, this is a phase in the process that federal agencies are required to have finished before they may implement rules. There is a degree of deference accorded to federal agencies when it comes to defining the words in their own industry. Nevertheless, they are not permitted to do so without providing prior notice to the public and without soliciting the public's involvement. Changing the regulations behind closed doors or in the metaphorical black of night is not something that agencies are allowed to do. At the same time that the ATF did with bump stocks in 2018, agencies are required to ask the public for opinions and take into consideration public opinion when seeking to implement new rules and regulations. This is done in order to guarantee that the public has a voice during the process. After receiving feedback from the general public, the agency is required to examine the comments, make any necessary adjustments to the final rule, and then provide the general public with information regarding the final rule, including what it involves, when it will be fully implemented, and how to comply with the rule. The new final rule of the matter. In a nutshell, the law reclassifies certain rifles that are already in existence and are fitted with stabilizing braces as non-federal firearms, which necessitates the registration of the firearm and the payment of a tax. The decision is made by the ATF using an approach that takes into account all of the relevant circumstances. This indicates that the decision would be taken on an individual basis, with consideration given to the characteristics of the firearm or firearms in question. Additionally, the worksheet, which was formerly known as Worksheet 4999, was not adopted by the ATF. However, while deciding whether or not a former handgun meets the requirements to be classified as a self-defense rifle, many of the same criteria that are in Worksheet 4999 will be subjectively examined. In conclusion, the ATF now regards stabilizing braces in the same manner as standard shoulder stocks.
In issuing the pistol brace final rule, did the ATF consider the several years of ATF opinions?
ATF derives its rulemaking authority in this matter from primarily the National Firearms Act.
Now, there has been several injunctions already issued by multiple courts.
And I'd ask that you please elaborate on ATF's decision-making process.
There are a few technical requirements to all of this, which will be detailed below. Recent developments in ATF regulations. The ATF evaluates whether a braced pistol is an SBR based on the new definition of rifle and 5 primary factors. These factors include length and weight, trigger position, optical design, manufacturer's marketing, and common use. If there is no rearward attachment, the firearm will likely not qualify as an SBR. The Justice Department announced a new rule on January 13, 2023, which took effect immediately and provided for a 120-day grace amnesty and compliance period. This rule will impact tens of millions of arm owners, including unlicensed possessors, non-Class 1 or Class 2 FFLs, qualified FFL importers or manufacturers under the GCA, and certain governmental entities. Compliance with the new rule on pistol braces involves registration, disassembly, conversion into a traditional rifle, destruction, and submission to the ATF for determination. Disassembly and possession of an unattached brace do not constitute possession of an SBR, unlike bump stocks, where possession of that disassembled item alone constitutes possession of a mash gun. However, some quick detach braces stored with pistols capable of accepting the brace may demonstrate intent to assemble an otherwise unregistered SBR.
If pistol brace owners fail to register their firearms with the ATF, they will be deemed felons.
And today they're calling on us to support their Second Amendment right to keep and bear arms.
Equipped firearms have been used in a number of high-profile mass shootings.
To comply with the new final rule on pistol braces, it is important to consult with an attorney licensed in your state and follow the 5 primary methods of federal law: registration, disassembly, conversion into a traditional rifle, destruction, and submission to the ATF for determination. The ATF has issued a final rule on stabilizing braces, which allows individuals or entities to obtain a free tax stamp for NFA SBRs that were previously classified as stabilized pistols. The amnesty period began on 1/31/2023 and allowed individuals 120 days to apply for a tax stamp via Form 1. However, the amnesty period has expired, and individuals or entities may still obtain a tax stamp but would still be required to pay $200. The final rule only supported a free tax stamp for a pistol equipped with a stabilizing brace. However, there will only be one category of SBR in the future, so the brace could be replaced with a stock after the tax stamp is approved. If the stock does not change the overall length of the firearm, no pre-approval from the ATF would be necessary. Holding the NFA item in an armed trust may be advantageous, as it allows multiple qualified individuals to possess the same NFA item. However, braced pistols must have been in the trust prior to January 31, 2023 to take advantage of the free tax stamp as part of the amnesty and compliance period. The U.S. District Court in the Northern District of Texas issued a nationwide preliminary injunction against enforcing the file rule on stabilizing braces, effectively making pistol braces not considered SBRs. The ATF will appeal the order to the Fifth Circuit, which is likely to uphold the permanent injunction. ATF appeals mock and BRD cases to First Circuit Court of Appeals. The ATF has decided to take a chance and appeal 2 cases about pistol braces all the way to the First Circuit Court of Appeals. They have now appealed the Mock v. Garland FBC case and the BRD v. Garland case, which was just decided and issued a nationwide injunction against the pistol brace rule. With this appeal by the ATF, that nationwide injunction is kind of at risk, although the ATF will quickly ask for stays of the injunction, which could put that nationwide injunction at risk. If you didn't know, Judge Matthew Kasmer recently issued a preliminary injunction in the BRT VAF case that blocked the pistol brace rule in its entirety, while that case moves forward in the lower court. That was a nationwide injunction against the pistol brace rule that a lot of people were talking about. Nationwide, you may recall that in the other case, the FBC mock case, the judge there, Judge Connor, issued a preliminary injunction but only protected the members of FPC and the organization itself, along with some individual plaintiffs that were named in the case. Then there were some other organizations like GOA, NAGR, and SAF who also got similar protections in their lawsuits under the district courts there in Texas as well. So a lot of these cases built off of what happened in March, and then the Brittle case was issued, which gave nationwide relief, but now all of that is at risk with these appeals. Now, all of these cases involve a granting of a preliminary injunction. A preliminary injunction is simply a temporary form of relief that remains in place until the cases are fully decided on the merits of all the arguments. So these orders and injunctions block the enforcement of the pistol brace rule only until the Brittle case or the mock case is fully decided.
The time that I've ever seen, Mr. Hunt, was a stabilizing brace ever used,
which would strike down the ATF's unconstitutional pistol stabilizing brace rule.
As a reasonable restriction. The issue today is very simple.
But the important thing to keep in mind with the Brittle case is that the decision was based primarily on what happened in Mock Garland and what the First Circuit also said in Mock. That means that the Brittle case is inherently tied together with the Mock case and is likely why the ATF decided to appeal both Mock and also BRD at the same time. Originally, in the Mock v. Garland case, the federal district court judge there, Judge O'Connor, denied the preliminary injunction which was requested by FBC. After that decision, FBC filed an interlocutory appeal, which is essentially just an appeal on that middle ground issue of the preliminary injunction up to the Fifth Circuit. The Fifth Circuit then reviewed that interlocutory appeal, reviewed the case, and found that Judge O'Connor should have, in fact, granted the injunction to FBC at least on their APA claims. Without getting into the weeds, essentially what the Fifth Circuit decision found was that FPC did show a likelihood of success on the merits of their case, and specifically on one of the main factors and one of their main arguments, which was that the ATF violated the Administrative Procedures Act when they put in place this pistol brace rule. The Fifth Circuit then remanded the case back down to Judge O'Connor for him to redecide the pistol brace preliminary injunction. The Fifth Circuit did not decide all the factors for the injunction, but they did rule that FBC showed the hardest aspect of the preliminary injunction test, which was a likelihood of success on the merits. On review, all Judge O'Connor was deciding is if the three remaining factors for an injunction were in fact met, if they were present, and what type of potential relief would he grant to FBC. On re-review, Judge O'Connor ruled in favor of FBC and gave them the preliminary injunction, but he only used it to protect FBC and its members. The previous Fifth Circuit decision, along with this new decision by Judge O'Connor, put the ATF in a really bad position. One of the most important things about this remand was that FBC was given the chance of success on the merits. ATF's risky move. Now, if the ATF decides to appeal again to the FFC, they will also be in a very bad position. This case, Mock, was kind of the first major pistol brace win and kind of set the stage once again for the BR nationwide PL injunction that was issued by Judge Casmer. Now, after that Mock case, Judge Casmer also ruled against the ATF on the pistol brace rule. He used the Mock decision as a starting point to then rule that the pistol brace rule must be stayed in its entirety. So that again was a stay on the entire rule, and that was a nationwide injunction. Now, with the Mock preliminary injunction and then also the R preliminary injunction, the question was, what would the ATF do in response? Well, the ATF has finally answered that question. The ATF is now completely just going to roll the dice and is filing appeals of both of these cases up to the Fifth Circuit. Now, this is definitely a risky strategy since, as mentioned in the Mock case, the Fifth Circuit has already reviewed this issue, and they already found that there was a likelihood of success on the merits when it came to the APA violations. So, all the Fifth Circuit will review in this Judge O'Connor injunction, which was granted, is whether or not he properly reviewed and found the other remaining factors. Again, this is not going to go the ATF's way. However, ATF cares a lot less about winning the injunction appeal, but instead what they are really focused on is getting a stay of the Mock decision and then also that BRD nationwide injunction.
It was even free to do so until June 1st. The ATF waived the fee to encourage compliance.
Arm braces are used to convert assault pistols into short-barreled assault rifles.
You know, and by the way, women's favorite weapon for self-protection is a short-barreled rifle.
This 120-day amnesty registration window recently ended at midnight on May 31st.
The ATF is going to ask the Fifth Circuit for stays on the BRD nationwide injunction, and if the Fifth Circuit does not grant that stay, then anticipating that the ATF will go up to the U.S. Supreme Court for an emergency stay. You may recall that recently, the ATF was successful in getting 2 stays in the Vanderstock ATF frames and receivers case. In that case, the Supreme Court issued a 5-4 emergency stay in favor of the ATF. That recent stay likely emboldened the ATF to try to get the same type of relief and stay in this nationwide pistol brace injunction case, and then also in the Mock case. So the ATF is going to risk the interlocutory appeal in the hope that they can probably get some sort of similar stay, either from the Fifth Circuit Court of Appeals or from the Supreme Court. We anticipated that one of the routes that the ATF was likely going to go down was still an appeal, and then also a request for a stay and then go up to the Supreme Court. And that is probably what the ATF's plan is now, and that's why they filed an appeal in both of these pistol brace cases. The nationwide injunction on the pistol brace rule is a little bit in trouble right now, but the hope is that the Fifth Circuit both denies the stay and then also rules against the ATF on the appeal. Thinking that it's very likely that the Fifth Circuit will deny the stay and rule against the ATF, but the big question right now is, what will the Supreme Court do in light of what they recently did twice in the frames receivers case? Now, people are not as confident in the Supreme Court right now, especially when it comes to something like a nationwide injunction. The Supreme Court seems to be very much against nationwide relief right now, so the potential is that ATF is banking on the Supreme Court being against a nationwide injunction on the pistol brace rule. That's all for this video, folks. See you next time.